Nabil and Miss Rachel. Hey everyone, we are from Group 9. Welcome to our forum today. My name is Tan Ho Ying, matric number A1837336. The topic that we will be discussing today is a brief discussion on economic theory of law and the application of maximization of wealth on the abolishment of death penalty. The basis of an economic approach to law is the assumption that people involved with legal system act as rational maximizer of their satisfaction. Economy is actually the science of rational choice in our world, in which resources are limited in relation to human wants. In order to achieve the objective of economic approach to law, there are some principles and guidelines can be followed. The first principle would be Pareto efficiency, and then the second guideline would be cost theory. Pareto efficiency is a situation where the welfare of one individual cannot actually be improved without reducing the welfare of another member in society. The allocation in Pareto efficiency means that the resources are allocated to be utilized at their maximum capabilities. And then for the cost theory, refer to a situation in which one outcome is the most efficient to everyone. This theory is actually attributed to Ronald Coase, and this theory states that where there are complete competitive market with no transaction cost and an effective set of inputs and outputs, and then an optimum decision will be selected. In the economic approach to law, Richard Posner's theory of wealth maximization plays an important role. Wealth maximization means that a transaction or any other change in the use of ownership of resources is advantageous if it increases social wealth. Posner said that an act of injustice can be defined as one that reduces the wealth of society.
Posner states that in terms of economics, society would be better off foregoing accident prevention if the cost of safety measures exceeds the benefit in accidents avoidance to be gained in incurring that cost. A rational enterprise that seeks to maximize profits will pay top judgment to accident victims rather than bear the higher cost of avoiding liability where the cost of an accident is lower than the cost of avoidance. But Posner's view doesn't seem to be satisfying because he assumes that the enterprise will place a greater emphasis on profit than on people's life. Even though the enterprise may be highly profit maximizing, after all, human beings do feel for fellow human beings and they may not give priority to profit.
Moving on to economic approach to property rights. Economic approach to property right is based on the explanation by Harold Templitz. He believed that property right derived from communal ownership. Communal ownership here means that the ownership of a land or other property by a community, so that each member has the right to use the property or a portion of it. Templitz hypothesized that property rights emerge when the social benefits of establishing such rights exceed their social costs. Economic value will always change with the passage of time, such as changes in science and technology, trades and commerce, and also the emergence of markets. Therefore, this will also bring changes to the law, where the changes in the law are done unconsciously in the early stage of development, but more consciously in the next stage. Next, we will be looking at the common law and economic analysis. Economic theories think that common law is efficient in its analysis. Common law is based on precedent. This is because when there are inefficient rules, parties are forced to litigate to overturn the rules to achieve the favorable rules. Therefore, efficient rules will always remain. If no one is interested in changing the precedent, then no litigation will be brought, leading to no changes in law.
You guys know that economic analysis plays an important role in the interpretation of a statute. An interpretation will surely affect the economy of the nation or the economic relation concerns. We can take a look into the traditional theories that take the archaeological approach. The purpose of the lawmakers in passing a statute is the main focus of attention. The legislative intent is ascertained by taking into account the legislative parts. The archaeological approach is more popular and widely regarded by attorneys and jurists, especially in a nation where parliamentary sovereignty predominates. Now, Now, let's take a look into the next principle, which is public choice theory and statutory interpretation. Legislation was treated as an economic transaction in this theory. The interest group is on the demand side, while the legislator from the supply side. The courts are instructed to weigh the benefit and drawbacks of each statutory interpretation. If a statute has the effect of distributing and courts, courts may interpret it in accordance with common law and revise it to account for new information. Courts should not apply a restricted interpretation. Courts should apply a restricted interpretation of statute for special benefits unless they are expressly called for by the law in cases when there is concentrated benefit and distributed cost. When a law has a concentrated cost but a distributed benefit, it should be construed to further public goals and take into account involving legal or constitutional principles. Last but not least, public theories propose that law should be construed to carry out the original agreement between interest groups when they have concentrated advantage and a concentrated expense. Finally, we will look into the economic approach to constitutional interpretation. Some views mention that the Constitution offers limited scope for decision-making by reference to economic analysis and consideration. In making the choice, the economic factor that without it, the state would be unable to engage in economic experimentation was taken into account. Even though it is reflected in legal gist of fine, private interest must be balanced with a public interest. Is demonstrated that another approach based on economic analysis may provide as a foundation of the right-based strategy.
Malaysia will do away with mandatory death penalty for crimes such as murder and drug trafficking. Judges will have discretion in deciding on alternatives to the capital punishment. Law Minister Wan Junaidi Tuanku said there will be further studies to ensure the rights of all the parties involved are protected. Malaysia has 33 crimes punishable by death. As of late 2021, about 1,400 people are on the death row. In a statement, he said Putrajaya has decided to substitute the mandatory provision with other types of punishments to be decided by the court. The decision was reached after Wan Junaidi presented to a cabinet on Wednesday a report titled Study on Substitute Punishments to Mandatory Death Penalty.
Hey guys!
Hi.
Did you hear about the recent death penalty abolishment?
Huh?
Yeah, it's very shocking news.
So, do you guys feel like it's needed? I mean, economically, I think it's efficient. What do you guys think?
I think according to what you said, economically, the death penalty abolishment is efficient. But how about from the moral perspective? Is it acceptable? What do you guys think?
I think death penalty seems to be just for both economically and morality reasons. However, in Malaysia, there has been a shift in the mandatory death penalty replaced by alternative sentences towards 11 crimes that includes murder and terrorism. One of the most argued points in the abolishment of the mandatory death penalty is that mandatory sentencing has disproportionately harmed the most marginalized and disenfranchised members of society, and how the death penalty itself has not served a unique deterrent to crime at all. In this clipping from an article from an Amnesty.org that I found, it is said that the death penalty does not serve its purpose as a deterrent and that it disabled the opportunity to visionary work towards enabling fair justice and addressing issues at the root cause. It is arguably difficult in determining a criminal case in the court of law as complex as a case of a murder sentence above it. Nonetheless, sparing a life for a crime thus done by free will is theoretically against the rights of possible victims' family wishes. OHCHR, or better known as the Office of the High Commissioner for Human Rights, however, believes that the right to life is the foundation of all human rights. Thus, taking a life is irreversible. and goes against our fundamental beliefs in dignity and all that humankind walk on the same earth. The law is constantly changing, and as it should, for the security, peace, and harmony of a country and the people. In imprisoning an inmate in Malaysia, it can cost around 38 ringgit and 41 ringgit a day. And at the end of the day, it can accumulate up to 2.4 million a day for the total prison population. Imprisonment does not mean an easy way or as the safest option. However, these prisoners can be put to work. In 2021 alone in Malaysia, 2 million ex-prisoners are said to be skilled for employment by the Deputy Home Minister himself, Ismail Muhammad Said. Meanwhile, imposing a death penalty cost the government 1,975 ringgit to hang a death row inmate, an additional of 800 ringgit if the body is not claimed. Rather than having to pay more to end people's life, I think it is a better to benefit from labor work instead. Hiring a foreign worker through an agent nowadays can cost up to 13,000 ringgit per worker. And as Posner's standpoint, everything is about maximizing wealth. Therefore, having a live inmates rather than dead ones can maximize the government to pay less to foreign workers and pay minimum wage instead to ex-convicts.
Due to that, legal theorists such as Posner in his article Utilitarianism, Economics and Legal Theory argue about the ethical inquiry of the death penalty. According to Justice Posner, he feels that wealth can be maximized through criminal law. One of his controversial views was that wealth can be maximized through the death penalty. It is because the cost to execute someone through the death penalty is relatively small than the cost to imprison someone throughout their life sentence. And economist Gary Becker actually support Richard Posner's view, as he said that even if we accept that the deterrent effect on murder is sizable, as the one who oppose the death penalty frequently say that the state have no moral right to take anyone's life, even the most heinous criminal. To demonstrate, let's assume that the number of murders is decreased by 3 for each murderer who is killed instead of, say, spending life in prison. This indicates that the 3 mainly innocent victims would die for every killer who does not receive the death penalty. According to this argument, if the government did not enforce the death penalty, it would be indirectly taking countless lives. The lives that are lost in this way are typically significantly more valuable than those murderers who avoid the death penalty. Because of that, the state has a moral duty to use the death penalty. If doing so, significantly lower the number of murders and spare the life of innocent victims. This shows that according to their view, the death penalty can actually benefit society and save costs.
Yeah, Iman, and a lot of people think that death penalty is easy, and its cost to carry out the act is much cheaper than non-death penalty cases, especially to feed the prisoners 3 meals a day in the prison cell. However, a lot of studies have proven that it's so much more expensive to execute someone in death penalty rather than them spending the punishment in jail. Sterling Goodspeed, he was a former district attorney in New York, argued that they could put someone in some fancy hotel for up to 70 years and feed them 3 meals a day, and it would still be cheaper than a single death penalty case. What people do not know is that death penalty is so much more complicated than merely executing them. They have to wait on death row before the execution can be carried out. Being on death row alone can be extremely costly because in most cases, inmates being imprisoned on death row can be up to more than a decade, if not more. Death penalty is, we all know death penalty is inhuman as itself, right? So a question arises on this topic of the death penalty being whether those death row inmates have to go through 2 different distinct punishments, which is first being the death penalty itself, and second being cooped up in a cell, which can be claimed as solitary confinement because, as we all know, people being on death row do not receive the same treatment as prisoners do. So death penalty is barbaric and not wealth maximized economically. Posner has given vivid distinctions between utilitarianism and wealth maximization, where Posner claimed that happiness and wealth cannot be maximized on the same account. So how can one put someone through death penalty, as it is depends on maximization, but it can be pretty costly, yeah? And somehow expect some sort of satisfaction that comes from it.
Sure, it may decrease the crimes, but in fact, the death sentence does not give the family happiness, but grief and sadness. On top of that, Malaysia has taken an advanced approach by abolishing mandatory death penalty, whereby the crimes with the punishment would be death penalty could be lowered or changed in sentence, such as life imprisonment, in proportion of the judges of the case verdicts. So this is crucial to take the country Malaysia to move forward, as taking someone's life can be very considered highly heinous. So Nimas, thank you.
Nevertheless, economic approach portrays a different perspective in which one thinks on what is worth having in trade with their money according to Durkheim. It is true that the death penalty might be considered an easy task to those who are responsible to do the act, for instance, the police officers. However, has anyone ever wondered about the after effects of the death penalty? Clearly, the families of the person who were involved under the penalty suffered the after effect of the punishment, death penalty. Porner, however, gives a different opinion in which he says that an act of injustice can be defined as one that reduces the wealth of society. In Malaysia, if this maximization of wealth is to be applied, perspectives from two different communities must be observed. In our country, having a criminal being penalized to death contributes to the decrease of rate of crimes in this country. But what about the maximization of wealth? On behalf of the police authority, had only the criminal been kept in the prison rather than being punished for the death penalty, social wealth is increased here. Keep in mind that the more advantageous resources were used, the greater the social wealth existed. To apply the family perspective in Malaysia by using the economic approach by Posner, it is injustice when the family of the dead have to bear the consequence for the cost of the dead, whether in grief or even in monetary form. Though the cost of punishment is cheaper since it is an execution, the cost to manage the graveyard situation would be given to the family of the dead. By all means, does this serve the purpose of the theory of maximizing wealth? Truthfully, the direct answer here is that it brings up the wealth maximization in which social wealth is in absence. So like by abolishing death penalty in Malaysia, this theory could be achieved. In my opinion, instead of giving death penalty, the best solution is to imprison the accused till the end of their life. With this, both the perspectives of the family and the country achieve social benefits. Not just that, it also increases the social wealth of the country since the prison will be used. Though it is limited in time for the family to visit the accused, at least they didn't lose a life in their family. Thus, for the country, it will be a lesson for the people to not do crime or even to prevent crime from happening since they were imprisoned for life. With this, the wealth of society increases as advantageous resources are used and also there exists in act of justice.
I think we can conclude that cost of death penalty now able to be seen in detail and quantified from investigation, attorney preparation, trial, appellate processing, execution procedure of a capital case exceeded the cost associated with life imprisonment murder cases. You know that in Florida, there are studies that mention that states spend 6 times as much money on a single capital case as it would to imprison a defendant until he died. I heard that Malaysians spend more than 1K just to execute capital punishment per inmate. Imagine spending that much money just to keep a person lawfully in a sense, when its statutory effects low, a possibility of convicted and innocent is there, including an incurable cost of expenses of the inmate during imprisonment. I mean, when you imprison, the aspect of purpose of rehabilitation when they go out, they can integrate with society and work as labor. It can be seen as progressing labor, but how about death penalty? A complete waste of taxpayer money and has no use for it at all. Doesn't legal economists such as Pareto, Calder, and Hicks, specifically Pareto criterion, want to achieve efficiency for design policy? Then does the death penalty contradict this theory, and meaning our law on death penalty are not economic efficient? I believe Posner also will agree with this conclusion, as maximizing wealth of the society can be also by giving to the society meaningful labor, especially we are now suffering on shortage labor and spend too much on foreign worker, which costs a lot considering the outflow of money will be sent outside to Malaysia. And I also will argue that we should find alternative punishment for imprisonment such as community service or restorative justice. to reduce imprisonment number and economically efficient. I believe Ronald Coase that proposed Coase's theorem will agree with me, as it will be the most efficient outcome to everyone and also serve its own purpose of punishment and justice.
To summarize, Richard Posner's theory of wealth maximization, Posner argued that the criminal law exists to be functionally efficient by serving the goal of wealth maximization. He gives a comprehensive rationale or theory of the criminal law and the criminal law doctrine, explaining how this law and doctrine serve to enhance market efficiency. Posner sees the criminal justice system as the instrument we can find turns to promote economic efficiency. Applying the family viewpoint in Malaysia, utilizing Posner's economic analysis is unfair when the deceased family must bear the cost of their loss, whether in terms of their grief or money. The cost of managing the Brunei scenario will be passed on to the deceased family, even though the cost of the punishment is less expensive because it is an execution.
In conclusion, one of the many principles in economic theory to law is the wealth maximization theory formulated by Richard Posner. According to Richard Posner, legal rules can be best understood as effort with an ultimate goal to maximize wealth. And in his own article, Utilitarianism, Economic and Legal Theory, he has argued that the principle of wealth maximization can also be applied in criminal law. Although from the perspective of morality, many might argue that death penalty should be abolished, and it is inhuman and it is a violation of basic human rights to live. However, from a viewpoint of maximization of wealth, the expense of executing the death penalty is relatively smaller as compared to life imprisonments, and hence should be implemented by the government, as the government will not need to support the lifelong living costs of the prisoners. A hypothetical situation is also raised by Gary S. Becker, the economics, to support Richard Posner's statement. He has quantitatively assessed the loss of life if life imprisonment is imposed rather than a death penalty. Gary assumed that the fear for death penalty has on the criminals will be able to indirectly lead to the reduction of three murder cases if one prisoner is executed. Hence, according to this hypothesis, it will be indirectly saving countless of lives if the government have decided to enforce death penalty.